How's everybody doing? Great to be learning with you on a Tuesday. Yom Shlishi. Let's light up the darkness. Who's in the house on a Tuesday? Yehuda in South Carolina, Stephen in New Hampshire, Tom in PA, Bella in Florida, Melissa in Great Neck, Sharon in New Jersey, Jonathan in Ventura, Guy in Ohio, Paul in the Great Northwest, Shauna in Canada, Aoife in Florida, Marjorie in Georgia, Bill over on the YouTube side. Will wonders never cease? Great to see you all. Great to be learning with you. I got to say, I've had a topsy-turvy, crazy, stressful day, and I'm so happy to just put it all aside and dig into the Talmud with you, my holy sisters and brothers. So, our daf today is Yud Gimel, page 13, here in Tractate Bava Metzia, the 22nd volume of the Talmud. We're going to open Mishna number 6 here in chapter 1, which actually begins on page 12b. Before I even read you this Mishnah, let me tell you where the law ended up, because it's just going to help us have some initial clarity as we dive into this. One who finds promissory notes may not return them to the creditor, even if they appear valid, and even if the debtor admits that he owes the money that is stated in the promissory note. Why? Why don't we return these to the creditor? In case the debtor and the creditor colluded to repossess property that the debtor sold, right? We're suspicious. There's a possibility. It's not that most people would do this, but because the possibility exists, we're going to be very cautious, right? So when somebody writes a promissory note, you lend me $1,000, so we write the promissory note together, I sign it, and it says that I owe you $1,000. And if we write into it that if I don't pay you, you can seize my property, right? So let's say my real property, land, that you're going to have a right to seize that land in order to satisfy, let's not call it $1,000, let's call it $100,000, right? You lent me $100,000, and it's going to be secured by, guaranteed by this piece of land that I own. Now you have a lien on that land. If I sell that land to someone else, but I don't pay the debt, you could go seize that land even from my purchaser. That's why people do due diligence when they buy property and make sure there's not some pre-existing lien on the land, right? That's why we do that kind of due diligence. That's why we have escrow companies and all the people that are involved when land is bought and sold. So, what are they suspicious of is that this promissory note that was lost and then found by somebody, right? So much of what we've been talking about in this tractate so far is the law of lost and found objects. So we're concerned that what the debtor and the lender might be up to is that, okay, you lent me the $100,000. I paid you back the $100,000. But in the meantime, I sold this other property. And now you're gonna use this promissory note and say, or maybe you haven't actually received it from me yet, but you and I are colluding, and you're gonna go to my purchaser and say, hey, you should have done your due diligence. There was a lien on this property that you bought from Sal. I'm taking it back. Now he's gonna have obviously a case against me because he bought property that he didn't know, had a lien on it. Even if he did, he's going to have an action against me to get his money back from the land that he bought. But in the meantime, you've got the land, and if I've given you back the money and then I split town, you can see how this kind of conspiracy could be real. This collusion could be real. And that's what the sages are worried about. The promissory notes may be returned to the creditor, meaning if they're found, only if it is clear that they do not create a lien on the debtor's property, so we don't have this issue. And if the debtor admits that he owes the money, because of course we might have the issue that I already paid back the money. There's no collusion. There's none of this conspiracy stuff going on. But I paid back the money. You gave me my promissory note. Then I lost it foolishly. I should have just destroyed it, right? Because now that the money's been paid, maybe I could keep a receipt showing that I paid you back. But the promissory note itself, I should destroy. Because if I lose it and then somebody hands it to you and you're lending money to lots of different people, you're not sure if I paid you back or not. Here's the promissory note. Oh, it must be that Sal hasn't paid me back yet. And now you can come and use it to collect again. Especially if I'm not around to defend myself. Maybe I died. Maybe you're going to use it against my heirs. You can see how this creates all sorts of problems. Now that's where the law ended up. Now let's get into the Mishna and the subsequent Gemara discussing this Mishna to see how they arrived at this. The Mishna, number 6 of chapter 1. With regard to one who found promissory notes, if they include a property guarantee for the loan, the finder may not return them to the creditor, as if he were to return them, the court would then use them to collect repayment of the debts from land that belonged to the debtor at the time of the loan, even if that land was subsequently sold to others. And if they do not include a property guarantee, then you can return them to the creditor, as in this case, the court will not use them to collect repayment of the debt from purchasers of the debtor's land. This is the statement of Rabbi Meir. Usually the majority is first and then the minority comes after. But now we're starting with the statement of Rabbi Meir, and we follow that with, and the rabbis say, right, the majority says, in both this case and that case, the finder should not return the promissory notes to the creditor, as if he were to return them, the court would, in any event, use them to collect repayment of the loan from purchasers of the debtor's land. This seems to indicate that a promissory note, even if it doesn't contain the language of a property guarantee, can be used to seize property of the debtor. And if he's already paid, this can create quite a problem. So that's the Mishnah. Now the Gemara. With what case are we dealing? What are the facts here? Now let's start to limit the types of cases where this Mishnah could apply. If we say it is a case when the liable party, meaning the debtor, admits that he wrote the promissory notes and that the debts have not yet been repaid, then when the promissory notes include a property guarantee, why should the finder not return them to the creditor? The debtor admits, yes, I wrote this promissory note. Yes, I owe that money. Yes, I have not paid that money back. So why not give that promissory note to the creditor, which is where it rightfully belongs? Doesn't the debtor admit to the debts? And if it is in a case when the debtor does not admit to the debts, claiming that he dropped the promissory notes after he repaid his debts, then even when the promissory notes do not include a property guarantee, why should the finder return them to the creditor? Granted, the creditor cannot collect these debts from lien property that has been sold, but he can collect from unsold property that the debtor still owns. And the returning of the promissory note would be disadvantageous to the borrower because he claims that he already repaid this loan. So the Gemara answers, actually, the Mishnah is referring to a case where the liable party admits to the debts. And here, this is the reason that the finder may not return the promissory notes. It is that we are concerned that perhaps the debtor wrote in the promissory note that he would borrow the money in Nisan, that's next month, but he did not actually borrow the money until Tishrei, right? So in other words, that's when Rosh Hashanah is. So we write the promissory note now, and I say, I'm going to borrow this money from you next month. But I end up not actually coming to pick up the proceeds of the loan that I'm taking for another 7 months. And in between writing the note and when I came to actually pick up the money, I had property and I sold it. So we included a lien on this property in the promissory note. But I didn't borrow the money till much later. And in the meantime, I sold the land. Now, when I actually borrow the money, I didn't own the land. I already sold the land before that. So the lien is no good. The lien that's written into the promissory note is not a valid lien, because when I actually come around to pick up the money that I'm borrowing, this land that I owned before, I've already sold it. So this, you can't you can't give a lien on land as collateral at the time that you're borrowing money if you don't own that land. And by the time I pick up the money, by the time I borrow the money, I've already disposed of that land. I've already sold it. So you can see how a lien written in a promissory note, when the promissory note doesn't actually give rise to a loan until much later, after that land is sold, becomes very problematic. And the creditor will then, if you then return this promissory note that was lost and found, and you return it to the creditor will come to repossess the land that was sold between Nisan and Tishrei from the purchasers, and that would be unlawful. It would be wrong to repossess such land, because when the purchasers bought the land, there was no lien on the land. They did their due diligence. There was no lien because I have not borrowed the money yet. And now if the creditor gets this promissory note that seems to indicate that that land does secure the loan, they could go and repossess it, and that would be unlawful. So the Gemara asks, if so, that's the circumstances we're talking about. If the court must be concerned that the date on a promissory note predates the actual loan, well, we should likewise be concerned that all promissory notes that come before the court are also perhaps predated. Why don't we always have this concern? And the Gemara answers, the credibility of all promissory notes in general has not been compromised, as they remain in the creditor's possession, which is the correct location in the case of an outstanding loan. The credibility of these promissory notes that we're talking about have been compromised because they were found in the street. Right? They were lost by somebody and picked up by someone else. That's why we have concerns about, underlying facts and what's really going on there. Now the Gemara asks, but with regard to that which we learned in a Mishna, tractate Bava Basra 167b, we may write a promissory note for a borrower even if the lender is not with him, because it is the borrower who assumes liability based on the note. So the question arises, how can one write this promissory note ab initio? Meaning, we might allow it later, but ab initio, right? And the Aramaic term for that, I think it's Aramaic, not Hebrew, is lechatchila, right? Meaning, okay, we'll honor such a promissory note if it comes before us, but because it causes problems, the sages prohibit writing it in the first place. Because it causes problems. Doesn't mean it's necessarily wrong, so we'll honor it, we'll deal with it, but you shouldn't do that ab initio in Latin, or lechatchila, I think it's Aramaic, in the first place, right? At the outset. So, one may write a promissory note for a borrower even if the lender's not with him, because it is the borrower who assumes liability to pay on that note. So the question arises, how can one write this promissory note lechatchila? Let us be concerned that perhaps the borrower wants to write the note as he intends to borrow money in Nisan, but will ultimately not borrow the money until Tishrei, and the lender might then come to repossess the land that the borrower sold between Nisan and Tishrei legally without a lien on it to purchasers, and if the creditor seizes that land, it would be unlawful. So Rav Asi said, and now we're on 13a, the Mishna is referring not to one who finds an ordinary promissory note, but to one who finds deeds of transfer. Now, when we're talking about deeds of transfer in this context, we're not just saying a contract that shows the purchase and sale of a piece of property. Rather, this refers to a promissory note that establishes a lien on the debtor's property from the date that the note is written, regardless of when he borrows the money. Now, it doesn't matter that I borrow tomorrow, next month, or in 7 months. The lien is present on my property from today. so that if I end up not paying the loan and I sell before I actually take the loan and I don't pay, then the creditor does have the legal right to seize that land from any third-party purchaser. Because the debtor obligated himself from that date, from when they've made the promissory note, even if he's not taking the loan on that date, the creditor has the legal right to repossess his land from any subsequent purchasers. Now the Gemara asks, if that is so, the following difficulty arises. How will one account for the ruling of the Mishnah here, our Mishnah, which teaches that if the promissory notes that were lost and found include a property guarantee, the finder should not return them to the creditor? And we established that the reference that what our Mishnah is talking about is a case when the debtor admits that he still owes the debt and that the promissory note should not be returned due to suspicion that perhaps the debtor wrote it with the intention to borrow money in Nisan but did not actually borrow it until Tishrei. And therefore, if the promissory note is returned to the creditor, he will come to repossess the land from the purchasers unlawfully. Because if Rav Asi's explanation is correct, why shouldn't the finder return the document? In other words, if it was one of these deeds of transfer where the lien is good from the writing of the promissory note, no matter when the borrower borrows, okay, then what's wrong with returning such a promissory note to the creditor if it was lost and then found? So the Gemara elaborates, let us see what the possibilities are. I gotta say, this is how I talk. You can ask Nina whenever we're facing some kind of a dilemma, a question, whether in our creative writing or making a shopping list or whatever issue that we're talking through, what I would always say is, well, let's see what the possibilities are before we go chasing one down because it sounds good. Let's just see what are the possibilities, right? So let us see what the possibilities are. If the reference is to a deed of transfer, right, a promissory note written and the lien is valid from that date no matter when the borrower actually borrows, didn't the debtor obligate himself that his property can be collected for payment of the loan from the date that the deed of transfer was written? And conversely, if the reference is to a promissory note that is not a deed of transfer, well, then there is no room for concern, as you said that in such a case, when the lender is not present together with the borrower, we do not write such a document. And the Gemara answers, well, Rav Asi could have said to you, although we do not write a promissory note that is not a deed of transfer when the lender is not present together with the borrower, with regard to the case in the Mishnah, it can be explained that since the promissory note was dropped, its credibility was compromised, and consequently, we are concerned that perhaps it happened to have been written in the absence of the lender, deviating from the standard procedure. Right? We have to be extra cautious with a promissory note that was somehow lost and found. That is not the normal course of, history for legal documents that just dropped on the street. Sure, it can happen, but when it happens, extra caution is required. Abaye stated an alternative explanation of the Mishnah that allows one to write a promissory note for a borrower in the absence of the lender. The document's witnesses, with their signatures, acquire the lender's lien on the borrower's land on the lender's behalf, despite the fact that the loan has not occurred yet. And this applies even with regard to promissory notes that are not deeds of transfer, that do not create a lien from the moment of their writing, even if the loan changes hands later. Abaye offered this explanation because Rav Asi's explanation was difficult for him. Since you said with regard to promissory notes that are not deeds of transfer that we do not write them when the lender is not present together with the borrower, there is no reason for concern that perhaps in the case of a found promissory note, it happened to be written in the lender's absence. So the Gemara asks, but how can Abaye's opinion be reconciled with that which we learned in a Mishnah on page 18a that we'll encounter next week? If one found bills of divorce or bills of manumission of slaves or wills or deeds of gift, or receipts, he may not return them to the people who are presumed to have lost them. And the reason is that perhaps they were only written and not delivered, because the one who wrote them subsequently reconsidered about them and decided not to deliver them. Now that's very interesting, right? Just because you find, for example, a will, right? Where the old gentleman says, I have reconsidered how I'm going to dispose of my assets upon my death, and as only one of my children has shown interest in me in the last year, I hereby give everything to him. And he wrote that because he was angry. And a week later, all the kids came together and threw him a surprise party, and he realized that the reason nobody had been talking to him is because they were all busy planning the surprise party. And he said, I'm glad I didn't file that will. I'm glad I didn't notarize that will. I'm glad I didn't say, this is my will. He just wrote that. It was a draft. And then he was ready to tear it up. But before he could tear it up, the heart. Now we find that will. Is that will really his last will and testament? No, it certainly does not evince what he felt, for decades when his will was his will. And just when he was old and near the end and there was a difficult year, he got angry. But he never meant to make that his final will, as we understand from the facts as I've presented them. But if somebody comes along and just finds that document by itself, sounds like this is his will. And that's why we're going to be very careful with documents that are not ratified properly. Even if there are witness signatures on them, if we can come up with scenarios where what the document seems to say is not what it says, we're going to have to be very careful. The Gemara asks, so we just said that and reconsidered about them. So the Gemara asks, if he reconsidered and decided not to deliver this document, this will or manumission of a slave or a gift or a receipt, etc. If he reconsidered and decided not to deliver that document, what of it? Didn't you say that a document's witnesses, with their signatures, acquire it on behalf of the recipient? If so, why shouldn't it be returned to him? And the Gemara answers, this statement that a creditor acquires the lien on the debtor's land immediately when the witnesses sign the document applies only in a case where the document came into the creditor's possession. But in a case where the document never came into his possession, as it was never given to him, we do not say that. Maybe it was written while the writer was emotional. And maybe he even got witnesses to come and watch him sign the document, and the witnesses signed the document. So the document was validly written and ratified, but he never delivered it. A get is such a document, right? A bill of divorce. Once it's written and witnessed, etc., that's a very powerful document. If he hands that to his wife, boom, they're divorced. But until he hands it to his wife, they're not divorced, despite the fact that it was written, dated, signed, and witnessed. There would need to be witnesses to the giving of the document to the wife, but that's something else. Now, the Gemara asks, but when the documents did not come into his possession, as it was never given to him, we do not say that. So the Gemara asks, rather, how can the Mishna be reconciled with Abaye's opinion, as it teaches, with regard to one who found promissory notes? If they include a property guarantee, he may not return them to the creditor. And we establish that the Mishna is referring to a case when the liable party, meaning the debtor, admits to the debts, and nevertheless the finder may not return the note, due to the suspicion that perhaps he wrote the promissory note with the intention to borrow the money in Nisan, but did not actually borrow it until Tishrei, 6 months later. So the Gemara elaborates, granted, according to Rav Asi, who says that the law that a promissory note may be written for a borrower in the absence of the lender applies only with regard to deeds of transfer, the Mishnah can be established as referring to promissory notes that are not deeds of transfer. And it is as we stated above. But according to Abaye, who says that a document's witnesses, with their signatures, acquire the lien on the lender's behalf, then what is there to say? Why shouldn't one return the promissory notes even if they include a property guarantee for the loan? And the Gemara answers that Abaye could have said to you that this is the reason for the ruling in the Mishnah. It is that the Tana, the rabbi of the Mishnah, suspects that there was repayment and collusion. Now we're back to this original idea that actually entered the reasoning that became the law that we read before at the very top of our class. We suspect that there could be repayment and collusion. Although the debtor admits his debt, he is suspected to be lying, as after he repaid the debt, he might have colluded with the creditor to repossess land that he, the debtor, sold during the period of the loan. And the debtor and the creditor would then split the money between them. The Gemara asks, but according to Shmuel, who says that we do not suspect repayment and collusion, then what is there to say? That's such a rare issue. We're not going to make laws based on that rare occurrence. Then how can the Mishnah be explained? And this works out well if Shmuel holds in accordance with the opinion of Rav Asi, who says that only in the case of deeds of transfer is it permitted to write a promissory note for a borrower in the absence of the lender. So accordingly, Shmuel can establish the Mishnah as referring to promissory notes that are not deeds of transfer. But if Shmuel holds in accordance with the opinion of Abaye, who says that a document's witnesses with their signatures acquire the lien on the creditor's behalf, then what is there to say? And the Gemara answers, Shmuel can establish the Mishnah as referring to a case when the purported liable party does not admit to the debt, and therefore the finder may not return the promissory notes to the creditor. He says, I already repaid it. So of course you can't return that promissory note to the creditor, who might then use it to collect again. So the Gemara asks, if so, in a case when the promissory notes do not include the property guarantee, why must the finder return them to the purported creditor? Granted, the creditor cannot collect the debt from lien property that had been sold, but he can collect from the debtor's unsold property, what he's still holding, even though the debtor claims to be exempt because he paid back the loan. And the Gemara answers, Shmuel conforms to his standard line of reasoning, as Shmuel says that Rabbi Meir would say, in the case of a promissory note that does not include a property guarantee, the creditor collects neither from lien property that has been sold, nor from unsold property. Therefore, there is no harm in the finder returning the promissory note to the creditor. And the Gemara asks, but since the creditor cannot collect the debt, why should the finder return the promissory note? What's the point? For what purpose can the creditor use it? And Rabbi Nassim Bar Oshaya says, the creditor can use it to cover the opening of his flask. Its only value is as a piece of parchment, right? That could be used just to seal a flask so wine doesn't spill out. And the Gemara asks, if the document only has the value of the paper it's written on, let the finder return it to the debtor to cover the opening of his flask. And the Gemara answers, the debtor is the one who says that these matters, the loan, never happened, and the promissory note is forged. Therefore, he has no claim to the paper on which the promissory note is written. Now we're on page 13b. On page 13b, Rabbi Elazar says the dispute in our Mishnah between Rabbi Meir and the rabbis, right, between Rabbi Meir and the majority, is in a case when the purported liable party, the debtor, does not admit to the debt. As Rabbi Meir holds that with a promissory note that does not include a property guarantee, one can collect the debt neither from lien property that has been sold nor from unsold property. And the rabbis hold that it is only from liened property that one cannot collect the debt using this promissory note. But one does collect the debt from unsold property, property that the debtor is still holding. But in a case when the liable party admits to the debt, says Rabbi Elazar, everyone agrees that the finder must return the promissory note to the creditor, and we do not suspect the creditor and the debtor of engaging in repayment and collusion to the detriment of one who purchased land from the debtor. That was Rabbi Elazar's view. Rabbi Yochanan says the dispute in a case when the liable party admits to the debt. Rabbi Yochanan says the dispute in our Mishnah is in a case when the liable party admits to the debt. As Rabbi Meir holds that it is only from lien property that one cannot collect a debt using a promissory note that does not include a property guarantee, but one does collect a debt from unsold property. And the rabbis hold that one collects a debt from liened property also. But in a case when the liable party does not admit to the debt, then everyone agrees that the finder may not return the promissory note, as we suspect that perhaps he already paid it off. You can see how Rabbi Elazar and Rabbi Yochanan interpret our Mishnah quite differently from each other. And it is taught in a Baraisa in accordance with Rabbi Yochanan, and from it there is also a conclusive refutation of one element of the opinion of Rabbi Elazar, and a conclusive refutation of two elements of the opinion of Shmuel. So the Baraisa explains, in a case where one found promissory notes and they include a property guarantee, even if both the creditor and the debtor agree about the existence of the debt, the finder should not return it to this creditor or to that debtor. If they do not include a property guarantee, then in a case when the debtor admits to the debt, one should return the promissory note to the creditor. But if the debtor does not admit to the debt, one should not return it to this creditor or that debtor. This is the statement of Rabbi Meir. As Rabbi Meir would say, with promissory notes that include a property guarantee, one can collect the debt from lien property, but with those that do not include a property guarantee, one collects the debt only from unsold property. And the rabbis say, with both this type and that type of promissory note, one can collect the debt only from liened property. One can collect the debt from liened property, even from liened property. That's a higher threshold than from unsold property. This is a conclusive refutation of one element of the opinion of Rabbi Elazar, who says that according to Rabbi Meir, with a promissory note that does not include a property guarantee, one can collect the debt neither from lien property that has been sold nor from unsold property. And Rabbi Elazar also says that according to both Rabbi Meir and the rabbis, we do not suspect that there is collusion between the debtor and the creditor. And the Baraisa teaches that with a promissory note that does not include a property guarantee, the creditor cannot collect a debt from lien property, but he can collect from unsold property. And the Baraisa also teaches that according to the opinions of both Rabbi Meir and the rabbis, we suspect that there is collusion between the debtor and the creditor, as it is taught that if one found promissory notes that include a property guarantee, even if both the creditor and the debtor agree about the existence of the debt, still the finder should not return to this creditor or to that debtor. So apparently, we suspect collusion. And this refutes Rabbi Elazar's opinion, who said that there is no suspicion of collusion, or that we don't make a law based on suspicion of collusion. So the Gemara asks, but aren't these two elements of Rabbi Elazar's statement that are but aren't these two elements of Rabbi Elazar's statement that are refuted by the Baraisa? Why did you state above that only one element was refuted? And the Gemara answers it is actually one element, as both elements have the same reason. Because Rabbi Elazar says that the dispute in the Mishnah is in a case where the liable party does not admit his debt. So he explains Rabbi Meir's opinion in this manner, i.e. that a promissory note that does not include a property guarantee cannot be used to collect the debt, even from unsold property. I'm almost done. Questions or comments, please get them in. The Gemara elaborates on the statement that the Baraisa serves as a conclusive refutation of two elements of the opinion of Shmuel. One element is like the element of the opinion of Rabbi Elazar that was refuted, as Shmuel also establishes the dispute in the Mishnah as referring to a case when the liable party does not admit to the debt. And the Baraisa states that in such a case there is no dispute. And the other element is that which Shmuel says, if one found a deed of transfer in the marketplace in which it is stipulated that the debtor transfers the rights to his property from the date that the document was signed, so the deed of transfer, he must return it, the finder must return it to its owner, and we do not suspect that there was repayment and that there is collusion between the creditor and the debtor. And there is also conclusive refutation of that statement as well. As the Baraisa here teaches, even if they both agree about the debt, he should return it neither to this person nor that person. So apparently we suspect that there was repayment, and all the more so here in the case of a deed of transfer when the liable party does not admit that he owes money. So the deed should certainly not be returned, as we suspect that there was repayment. Now, obviously, this was complicated. This was challenging. If you could stay with it and hold by the logic the whole time that we're learning it, your mind has elevated. You have sharpened your reasoning, analytical, Talmudic skills quite a bit if you could stay with all of that. It's not easy stuff. But if we go, zoom up to 30,000 feet for a second, what are we really talking about? You find documents that are evidence of a loan that was made from a lender to a borrower. And the elements that we're concerned about was, first of all, why was this document lost? That's unusual. Number two, does the document contain a property guarantee so that there's property out there that can be seized using this document? Has the loan already been paid back? In which case, again, we're wondering, why does this promissory note still exist? And why was it found on the ground, on the road, or in a marketplace? Is it possible that the borrower and the lender dropped it there on purpose so that there could be a real conspiracy theory, elaborate type of collusion, so that there was a borrowing and a lending, and in between sale of a property that they're going to use to take back and keep the money between them, that the purchaser paid for it, who does have a right of action now against the guy who sold it to him, who's the borrower in our promissory note, but maybe he splits town and can't be found again. So there's a lot of concerns, and the sages, as you can see, are being ultra cautious to make sure that to the best of their ability, they are foreseeing, all of the possible ways that people could use the system and abuse the system, and to try to create a just result. I'll just mention before I go to questions and comments that tomorrow, Wednesday, we're on the regular schedule, 6 p.m. Pacific. Slight chance that I'll be late because I'm going to be in an all-day training for my CCW. Sadly, some of us feel that we need to protect ourselves because these are dangerous times. And I agree with the requirement that anyone who is going to carry should go through a lot of training. I already have gone through a lot of training for my exposed carry permit because I've told you about Maganam, the security work that I do at my synagogue. But this is another step above that to have CCW in California, which is quite difficult. And I'm doing an 8-hour training tomorrow to, get the paperwork done for that license. So it ends at 5. But I'm going to be, depending on traffic, could be more than an hour away. So if there has to be a delay, like yesterday, or was it yesterday? I think yesterday, I will post, the alert that the class will be delayed half an hour, whatever it is, on the Accidental Talmudist Facebook page. But probably it won't be necessary. We will be on time, but just in case you heard it here. Okay. Questions and comments on Bava Metzia, Daf 13, page Yud Gimel. Elvis, general comment. I'm always awed at the way the Torah and the Talmud take such great care to set out guidelines to ensure the integrity and justice regarding family, community, property, and most of all, our worship of Hashem. I don't think I could have stated it any better. Beautiful comment, Elvis. Thank you. Jonathan. Now, I am wondering, if we find a promissory note and we determine we should not return it, what do we do with it? Burn it? Give it to the court? I assume that we should not leave it in the street and not get involved, since that may cause someone else to trip into a trap, right? A stumbling block for the blind. That's such a good question. We haven't established that. It's a really tricky question, because certainly we're not going to give it to the creditor. That's what we're talking about, right? If these conditions are not met. And by the way, you see how difficult this law is to understand. So if you're just an average schmo and you're walking around, you see this promissory note, you're like, did we learn something last year about returning these things? Should I give it to the creditor who's named on it or not? Seems like you can't go wrong by giving it to a Talmudic authority, right? Give it to your Rav, give it to the local beis din, the local rabbinic court, and let them sort it out, right? So I think you can't go wrong by giving it to the court, because the court will know what the law is and whether it can be used to seize property or not, whether it should go to the creditor or not. So I think you can't go wrong by giving it to the halakhic authority. Shona, and please tell me if I'm pronouncing your name right. It's spelled S-H-O-N-A, so I'm guessing it's Shona. Could be Shona. Shana. I don't want to say it wrong. Let me know. Why would someone write a promissory note in advance of borrowing money? Why not wait until the transaction takes place? If the person doesn't borrow the money, a dishonest lender could take advantage of him, saying that he did not borrow the money because he wrote the note. Excellent question. And I would say, in the modern world, this whole thing makes no sense. But in the ancient world, not everyone had ready access to a scribe who could write out such a note and write it properly. So maybe a scribe is passing through a village. One guy's thinking about borrowing money. He's hoping he won't have to. But just in case, he's concerned that later when he will need the money, there won't be a scribe around and he won't be able to borrow the money until he can find the scribe, and then in his hour of need, he won't have the money. So maybe that's why he writes it now, as a just in case, and then all of these problems would follow. And lastly, Jonathan, on page 13a, notes, in the opinion of Rav Asi, who says that only in the case of deeds of transfer is it permitted to write a promissory note for a borrower in the absence of the lender. And I'm wondering how this can happen. Earlier we learned you can't do something to the detriment of someone who is absent when they aren't there. So is this agreement to his benefit or his detriment? I think what we're saying is, the lender was certainly present for giving the money and writing the basics of the promissory note. Or even maybe he just lent, well, how about this? Maybe the lender just lent the money, right? He trusts the borrower. He says, yeah, make sure that you write a proper promissory note. Here's the money. I got to go. And they're friends. And so the borrower is going to make sure to create the promissory note, even though the lender had to leave, because the lender was kind enough to lend him the money. And so that's why the lender's gone, but they are writing the promissory note entirely for his benefit. Because without the promissory note, there's no evidence of this loan. He would never be able to collect. So the only reason we're writing this note is for the benefit of the lender, and we can do that even in his absence. But here where they're saying that, but certain aspects of that, even if it's to his benefit, we're not going to do in his absence. So there's a limit to how much we'll do, either because it could be to his detriment, or because it's just too much to do in the absence of somebody, legal importance, something so legally important. I'm sorry, I had to think about it a little bit more. I don't have an adequate answer for you, but it's my impression that since it's for his benefit, we can write the note, but if there's any aspect of detriment, we can't add that clause. Okay, that's what I've got for us today. And with God's help, we'll be together tomorrow at the regular time, 6 p.m. Pacific. Have a good night.